It's my pleasure to introduce Natalia Lukashevich, who is talking about the maker movement. And I think this is a pretty interesting topic because when you're a maker, you start to experience problems that are usually not really yours to think about. For example, you usually don't really think about marketing your stuff or whatever, and you might think about copyrights. And this is something where we'll hear many details about from Natalia, who has done her PhD thesis on this. So great applause for Natalia.
Okay. Good evening, everyone. It's a great honor for me to be here. I'm a PhD student, and I will present you my PhD research I conducted on pattern flexibilities. In my research, I did comparative analysis, and I tried to analyze the pattern flexibilities from the point of view of freedom to operate they provide. And I transferred my results on the maker movement. And today I would like to give you some guidelines on the allowed use on patents so that you can be free in your making activities. My talk will consist of two parts. First, I would like to give you an overview of patents, what patents are, how patents are built. I would like to also explain you the rights conferred with patents, and I couldn't resist and decided also to highlight questions that are currently debated on the patent system. Then the biggest part of my talk is on patent flexibilities. I will explain what patent flexibilities are. I will present you a catalog, and then I will focus on chosen flexibilities that can help you in making and will support your activities. So first, patents. A patent right is an exclusive right upon the use of a technical solution granted to an inventor. Patents must meet three requirements. Well, these requirements differ, depends on jurisdiction. Here, the main one. So patents must be novel, non-obvious, and industrially applicable. They are disclosed, the solutions are disclosed in the patent application that is published after 18 months from the date of filing patent and granted by a patent office. And that's the main difference between the copyright, because copyright is granted automatically, whereas here you have to apply and you have to pay for a patent. Just to give you an example, here in Germany, the first minimum cost of a patent is around 5,000 euro, this including patent attorney. And of course, if you apply in more countries, the cost gets higher because you have to hire more patent attorneys, you have more administrative fees to pay, etc. Patents are granted for 20 years calculated from the date of patent application. This is how a patent looks like. Patent claims are the core part of the patent, where you determine the features of the protected technical solution. Patent claims are supported by description and drawings. In description, you present the problem, the solution, the prior art, and the examples. Patent applications must comply with the requirement of sufficient disclosure. As said, patent claims are supported by description and drawings. They cannot be broader because then they are not supported. Sufficient disclosure is called also enablement. And with this disclosure, a person skilled in the art should understand the technical teaching and should carry out the solution that is protected. A modern patent system are around 200 years old. The first US Patent Act was enacted in 1790, then was followed by France. Of course, the first patent acts were afterwards modified and adjust to the conditions and the needs, technological needs. Patents have various justifications and various theories. Here I presented only three I found the most important. First, reward theory. Patents are reward for undertaken efforts and investment. This reward theory underlines other theories, and I find it the most important. The reward is the market monopoly for 20 years, and the exclusivity on the market to use, to license, and to enforce the right. Then another theory, incentive to disclose, as mentioned already. The sufficient disclosure is the important requirement for every patent application. The underlying concept for this theory is the belief that trade secrecy impoverishes the society and the public. And the inventor, so to say, sign a contract. The inventor reveals, discloses the technical teaching, and is granted the patent protection. And this disclosure helps the society to grow, to progress, and to develop. The third one I would like to highlight here is incentive to invest. Very often, patents attract the investment. The perspective of patent protection is interesting for investor to simply pump into money in a given project. What gives you a patent? Well, as said, it's an exclusive right, and it gives you the right to prohibit others from using, making, selling, offering to sell, or importing the technical teaching that is protected. Legally, it's called exclusive right, but this exclusivity is translated as market monopoly, because it gives you this monopoly on the market that you as an inventor, as the patent holder, you have the full exclusivity to monetize the patent. And here, we call copyright law, patent law, intellectual property. And this intellectual property has strong economic implications. That's why I opt for slight modification of this terminology. Maybe it sounds somehow irrelevant, but when we hear property, we know that we should protect the property. It's like, holy cow, we cannot touch it. And that's why I think we should call patent law, copyright, trademark law as intellectual assets, because this term actually clearly pronounces the purpose of the system. Now patents are tradable goods, as I will show you in next slides. Yeah, questions. So there are various questions about the current state of the patent system. First, patentable subject matters. The scope of patentable subject matter is growing. Initially, patents were granted for tangible goods, so devices, elements, some components. But nowadays, more patents are granted on the intangible. There is a great issue with software patents, that quality is often challenged. There are also biotechnological patents, and still controversial whether we can, whether we can protect something that exists in the nature. Currently, only in vitro processes are protected. So nothing that is done on human body in vivo can be protected. Then patent quality. And here, a small picture. So when you attend lectures on patent law, you learn that there is a state of the art, so everything that is known. Above this level, there's a field of obvious solution based on the state of the art. And above this obvious level, there is non-obvious level of technical solutions, because patents are granted should be granted for outstanding solutions. That's the theory. In my view, and I'm not alone, the practice shows something different. And this is pretty scary. because the level of the patent threshold is currently pretty low. Maybe some of you follow the website of the Electronic Frontier Foundation. They have very funny stuff, namely they post every month a stupid patent of the month. And I think it was November, October, it was a patent on filming yoga class. And when I talk with practitioners, they find such examples as anecdotes, and I don't think this is the case, because as mentioned, there are software patents, and the level of invalidity in this group is extremely high. So we have a system with poor quality patents. It's estimated that around 50% of patents can be invalidated, and it's pretty scary because I cannot think of any other industry sector with this level of failure in production of efficiency, but the patent system is doing very well. And as I said, 50% in general, and around 70%, if not more, of software patents. Bad patents land by patent trolls. Currently, we don't talk about patent trolls. There is a nice term for this, namely troll-like behavior. So these are companies that aggregate patents for the sole purpose of their enforcement via demand letters. Of course, companies sell bad patents to patent trolls, simply to monetize them if they cannot license on normal basis. Another plague in the field of patent litigation, because of course there are certain patent litigation with patent trolls, there are patent wars. The most famous Apple versus Samsung, and others, Google versus Yahoo. As said, patents became tradable assets, and that's why I would like to repeat it. I propose the term of intellectual assets. Just to give you an example, Google bought an IP portfolio from Motorola, around 70,000 patents for $12.5 billion US. And it's somehow surprising that Google buys Motorola patents. Why? Because Google wanted simply to increase its IP portfolio to be stronger and harder to be attacked by competitors. So this is the background, and against this background, I analyze patent flexibilities. What are patent flexibilities? Patent flexibilities are tools, legal tools, that limit the scope of patent exclusivity. The main purpose, well, there are a couple, to safeguard the balance of interests, the interest of the patent holder and the interest of the society, of third parties, of users. Then they facilitate workings on patented solutions. I will name a couple of examples. And they can be used as a defense in patent infringement cases. Patent flexibilities are known rather as patent exceptions. The term exceptions is associated with something rare. And so it means that they limit the scope, but to very narrow and rare extent. The underlying provision for all patent exceptions is the Article 30 of the TRIPS Agreement, Agreement on Trade-Related Aspects of Intellectual Property Rights from '94, that sets the minimum standard, protection standards globally. And it says that an exception must be limited, cannot unreasonably conflict with the normal exploitation of the patent, and cannot unreasonably prejudice the interest of the patent holder, taking into account the interests of the third parties. It's pretty complicated. This article was formulated in abstract way, and it stipulates so-called three-step tests. So every patent exceptions, every legal tool must comply with all three requirements. And if it fails, if a certain legal solution fails to comply with the first step, which is limited exception, so it's something even narrower than an exception, it's out of the game. The exception cannot be introduced into the legal system. In my research, I focused on flexibilities, exceptions, that either allows you to freely work on patented solution or can be used as a defense in case of patent infringement. The main problem with making is its public character. Because as long as you make in garage or in a basement, everything is okay because nobody knows about your solution, about your ideas. But with the moment when you start to share and you post your ideas in the internet or share with friends, and at some point some of you might become very successful in your making, then you might get into troubles with patent law. There are various types of patent exceptions, patent flexibilities, but the abundance of tools is rather misleading because the scope of application is very narrow. In my research, I focused on four, in my opinion, the most important patent system, which is Germany, the United Kingdom, the United States of America, and Japan. Here in my talk, I decided to extract, as far as possible, commonalities between those systems, and there, where necessary, I will get more into details into differences so that you can understand and be more aware of the slight nuances between the systems. So the catalog, as said, it looks pretty fine because there are various tools, but my analysis led to the conclusion that there are only a few that would apply into making scenario. And here I would like to also underline that none of these tools will support making 100%. It's rather that you have to adjust making to these exceptions to feel safe and free in your making activities. So the first one, private and non-commercial use. This is statutory limitations in the United Kingdom and Germany. I haven't found much about private and non-commercial use in the United States, only in terms of repair, and I will talk about repair doctrine in a couple of minutes. With regard to Japan, I also found only a short comment that the system accepts, although there is no statutory limitation with regard to this type of flexibility. So what is about private and non-commercial use? These two features cannot be separated. So you cannot work privately and earn money and then work publicly and do not earn money and invoke on this flexibility. Private use is understood as use at home, within individual sport activities, or for personal use, but as I found, it applies to this US system. Personal use can be also challenged and found as an infringement of patent law. And then non-commercial use is pretty clear. You cannot earn money. You cannot conduct any business activities if you want to invoke on this flexibility. So here, I decided to focus to tell you what is not allowed. So, of course, you cannot produce and you cannot sell. I found as an example the use of patented lamp in a waiting room in a doctor's office. If you use a patented device at work, even if you, for instance, if you are a freelancer and you have in your office some certain devices, you cannot invoke on private and non-commercial use because you apply this device for commercial purposes. Of course, resale of purchased device. Then if you make an item, here give an example of a software for private purposes, and then you use this software for public programs, private and non-commercial use does not apply. And the last example, this was pretty tricky because it's a case from 1887 where defendant built a well on a farm and used it personally for personal purposes. And this use was found as an infringement of patent rights in the United States. The experimental use. I think this might be the most useful type of patent flexibilities. You can find it in all systems. And I said it's the most important patent flexibilities because it serves the technical progress, the further development, the further improvement of technical patented solutions. But the most important part in this patent flexibility, it applies only to experiment you conduct on the patented subject matter. So if you use a given patented device to test something else, this use will be not regarded as experimental use. There are certain differences between jurisdiction. So the main prerequisite for this patent flexibilities is adding new knowledge. So this prerequisite must be met. Then commercial use. Certain experiments may lead to commercial product. For instance, you improve some chemical substance. German system is pretty generous and it accepts this further applications of results, but not other system. And so in the United Kingdom, the experimental use must dominate over the commercial purposes. You might monetize the results, but still you have to prove that the main focus was on experimental purposes. Both German and UK system, they do not provide any quantitative limitations in the provisions. However, the scope matters. So you cannot claim that it was experimental use if you tested a great amount of patented solution in various places. It all has to be in experimental amount to be considered as experimental use. The United States have very, very narrow application scope for this flexibility. It applies only when conducts are for amusement, idle curiosity, or strict philosophical inquiry. Additionally, the courts introduced the term of legal interest, legitimate interest that pertains to business objectives in your experimental research. And to give you an example, very controversial case, Dr. John Madej versus Duke University. Dr. Madej, he left the university and he left his laser devices, patented laser devices, that the Duke University used further with students to conduct experiments. And he accused the university of the infringement of his patents that were embedded in this particular laser device. And the court found, based its argumentation of the legitimate interest. Here, legitimate interest of the university was the education. And pretty controversial and shocking for many, because it's obvious that university educate people. But to educate people, university gets money from the students so that they can use labs and devices. And that was found as a business objective of Duke University in terms of the use of this particular device. With regard to Japan, based on resources I had, of course, adding new knowledge is the main requirement. The system, the legislator allows also experiments to obtain regulatory approval. This applies mainly for pharmaceutical companies that start testing certain drugs before the expiration of patent terms for primary drugs to introduce generics on the market. So this is covered by experimental use in Japan. Summing it up, you can invoke on experimental use if your making serves the following purposes. You find new applications, you try to understand the technical teaching, you assert sufficiency, applicability, you discover something unknown, you test hypotheses, you want to determine the working of certain patented solution in various conditions. And last but not least, remember about the scopes of the samples. It cannot be oversized. And what is not allowed, you cannot conduct experimental experiments to find market information, to measure whether a certain solution fits with your business profile, or to assert a third party that the product works. There are also situations where you may work on a certain solution, and later you will find that this solution was patented and you were the first. So then we talk about the prior use. So it's about using a certain patented solution before its priority, before the patent application was filed. Prior use does not constitute the prior art. So you cannot claim prior use to invalidate a patent. And of course, you start thinking about prior use when you have the situation of patent infringement. Okay, so what do you need to apply to invoke on prior use? First of all, you have to use the patented solution, and it cannot be stolen patented idea. The prior use served the protection of business activities. So if you claim the prior use, you must show that there were certain commercial activities undertaken or serious preparations for further commercial applications. And there is no remuneration, at least this is a general rule, there's no remuneration for the patent holder, and prior use, the right you get is not a license. But to prove the prior use, you must have flawless evidence. It's very hard. Otherwise, if the courts see that there is something lacking, then you are on the border of patent infringement. And if it's the other side, one may think that the other party simply stole the idea and risk the patent invalidity. And the prior use continues after the grant of a patent. So you can freely and safely develop your business model with regard to the certain patented solution. Then repair doctrine. This is very tricky stuff because it's very simple, and I think everyone understands intuitively what it's about, that you replace a broken part to make a certain device usable again. As said, tricky because it's simple when it comes to definition and very complicated when it comes to the application. The repair doctrine bases on the notion, depending on the jurisdiction, on the exhaustion principle or implied license or first to sale doctrine. All of them concern unconditional sale, so there are no contractual limitations upon the use of a patented device. Think about simply buying some electrical device. You take it and you are allowed as a user to repair it. The underlying concept for this is the compensation. You pay once to the patentee, and the patentee cannot demand double payment after he was paid for this device. The repair doctrine is often confused with reconstruction, the concept. There are very blurred and clear borders between what's repair and what is reconstruction. So you can prolong the life of a patented device by replacing the broken element, but you cannot make a device anew. The question is, what is when? And the case law in all studied jurisdiction is very rich and abundant, but it's pretty difficult to extract clear guidelines upon what is exactly allowed and when. After all, you have to get into the patent claims, analyze, understand the technical teaching, what was changed, and whether this change replacement is repair or reconstruction. Reference points, this is the identity and essentiality of the element. so how essential, how the element contributes to the technical teaching. Very often inventors explain or intend even for certain parts to be replaced, then it's okay. Yes, so I tried to present you certain rules that might be useful for you when you make on things. So if the replacement was intended by the patentee, you can feel safe and you can replace an element. If an element is of a short lifespan, for instance, a syringe in a syringe system, obviously you cannot buy a new device if just you need to replace a syringe. Then if your making that does not change the identity of the device, then your making might be considered as a repair. In the United States, there is an idea of idea of akin to repair, so replacement akin to repair, where you can really change something in the device, but this applies only to unpatented elements. So again, you have to read the claims, patent claims, and understand whether this certain element is outside or within the scope of patent claims. And if a patented solution is a combination, you may replace individual elements because they are not covered by the patent, but the combination. What is not allowed? So if your changes go beyond the necessary scope to restore normal utility of device, if you replace an essential part, in terms of, in the light of patent claims and technical teaching, and if you remake or make new a patented device, then you cannot invoke on the repair doctrine. And challenges. As said, it's very hard to extract guidelines to say, okay, in this situation, this is allowed or not. There are various approaches, legal approaches. Sometimes one court applies one legal doctrine and reaches certain solution, then the Court of Appeal applies different doctrine, and then you have completely different solution. That's really tricky. Then you have to always identify patents in a given patented device. And nowadays it's pretty complicated because I cannot think of any device that would consist of a single patent. There are at least 10, and you have to get into patent claims, understand what was patented, what you want to change. There is a lot of responsibility on your side, after all, unfortunately. Then, there are also situations when your solution might be claimed as equivalent to the patented one. And what is an equivalent? An equivalent is an element that solves the patented the problem in the patent in an equal but not identical way. And then we have the situation of equivalent of non-literal infringement. Every patent has a certain protection scope. So the core is the patent claim, our patent claims, as I told you, where you determine really the features of patented solution. Then you can expand it a bit by reading descriptions and drawings to understand whether there are other solutions that fit into this patented solution. And all of this is estimated at the time of patent applications. But technology progress is going forward, and there are some solutions that cannot be anticipated by the patent holder, and equivalents are determined at the time of infringement. To give you an example, there was a case in the United Kingdom called Amgen, where patented solution concerned erythropoietin, the isolation of this gene, And the patent concerned isolating the gene and activating it externally and then introducing into the host cell. The defendant found a new way of gene activating and did it internally, so in the cell. And well, I'm not a technical expert, but I found these two methods somehow completely different. And it was so that at the time of patent application, this internal gene activation method was not known, but at the time of patent infringement, the court actually started considering whether these two methods can be found as equivalents. And if patent claims were not really focused only on this external gene activation formula, and if patent claims were formulated in more abstract way, then most probably the second way of gene activation could fall into the scope of patent claims and patent protection. And I would like to present you way you can defend yourself that your solution is not an equivalent. And in Germany, there is a Formstein doctrine. This is based on a case from 80s. And the patented solution concerned curb stone built on the side of the road. And the technical solution referred to the watering lines in the stones built on the road. And the infringing solution concerned also stones built on the side of the road, but with the gaps between those stones. And the court found that the element was equivalent because actually it had the same function, but it was not identical. Moreover, this is very important if you want to invoke on this protection of Formstein doctrine. The court found that this solution was not patented in the light of the prior art. So when I go back to this slide, so this solution was outside the protection scope of the patent, the infringed patent on curbstone. All defenses in equivalent, all defenses that concern equivalency are very challenging because you have to determine the scope of equivalence and then find whether your solution, your mate solution, falls within the scope of protection. In the United States, there is reverse doctrine of equivalence. But first, I would start from the doctrine of equivalence. It says that an equivalent must have the same function, must carry out the patented the technical teaching in the same way, and must obtain the same results. When it comes to doctrine of equivalence, well, the pioneer inventions have much greater equivalency scope than improvements. And reverse doctrine of equivalence says that there is a literal infringement because the equivalent has the same function. And in the case where this doctrine was formulated for the first time, the patented solution concerned air brake system, and the infringing one, fluid pressure system. So, of course, both systems had the same function and the same effect, but the second one, the infringing one, carried out in substantially different way. It's very challenging to prove, and I cannot recall any case where reverse doctrine of equivalence was successful. But if you try, then you have to determine, it's much easier to determine first the scope of equivalence, to see what is non-equivalent, and you must read the patent claims outside their literal meaning. In Japan, I call it Japanese mix because it's a mixture of the US doctrine of equivalence plus the Formstein doctrine from Germany. And in case there is an infringement concerning Japanese patents, you may seek the protection which is in the fourth requirement of the doctrine of equivalence, and you may try to prove that your solution is not a patented one, is in the light of the prior art. You have to, in other ways, prove the obviousness of this element. In the United Kingdom, there is the fence called Gillette. It's from 1913, that was the time of the patent infringement and the litigation. And this concerned safety razor system, improved safety razor system of Gillette. And then the defendant proved that this improvement was obvious and anticipated in the light of the prior art. So if you try to protect yourself based on this defense, you have to prove that the solution was obvious from the prior art. It has very high standard of proof. As said, I have to repeat again, the scope of protection and equivalency must be first determined. And it serves patent invalidation, because when this doctrine of this Gillette doctrine might have twofold outcomes. If patent claims include the infringing element, then, and if you are successful in claiming this defense, then first of all, there is no infringement state, and the patent is invalid. And then, if patent claims do not include the infringing element, first of all, this is kind of happy, because there is no infringement and the patent remains valid. Summing it up, I reached the conclusion that patent flexibilities have extremely narrow scope, and they do not address making needs of makers in 100%. As mentioned already in my talk, it's the other round. If you want to seek the protection in the patent protection in a way that you want to make freely, then you have to adjust your making to patent law, not the other way around. And as long as your making is low profile, and the best scenario, you stay in garage and basement and nobody knows about your ideas, then you're absolutely safe. But with the moment when you go publicly and then become successful, then you have to consider the problems of patent infringements. Just to name a few recent examples from Kickstarter, this Formlab that was sued by 3D Systems. And then with regard to the patent system on the whole, I see very strong closing tendencies. There's the dominating mindset is that we want to have strong patent system. A strong patent system means more protection for patentees. There is ongoing debates on improving patent quality. In my opinion, higher patent quality would solve a lot of problems that we have currently, because we would have simply more free space between the state of the art and the patent threshold. But currently, I haven't seen any virtual step undertaken to solve the problem, only a lot of discussions, but hopefully, and I hope I can participate in this reform, it will take place. Thank you very much.
Thank you all for that round of applause, and thank you for the whole speech. So, are there any questions then please line up at the microphones.
Here, also in the internet.
Where's my audio angel? Okay, let's start with microphone 1.
My question is regarding to international patents. So who has the power of changing the process of developing law for these patent-making processes? And the second part is, how come it's still possible to patent ideas that you don't have any intent of realizing? So technological development is being blocked in a way.
Well, answering your first question, who influence? Well, big companies and powerful stakeholders, that influence the lawmaking on the international level and countries.
So to which level are states being involved and the national?
Well, for instance, the TRIPS agreement, this is international agreement signed by countries. So these are states, and in case of the TRIPS agreement, the United States played the most important role in shaping and setting the protection standards. And could you repeat your second question?
I had the intention that it's possible that corporations buy patents of ideas or projects that they haven't really any intent of realizing. For instance, hydro cars. So development is being blocked in a way because oil companies buy those patents, for instance.
Yeah. Well,
why is that legal?
Well, why is that legal? Because the system gives them. If you apply for a patent, you have this patent exclusivity, and it's on your discretion what you do with patents. And you can use patents to eliminate competitors and to block others, and to demand license if you want to, develop certain patented solution.
But do they have to show that they really have an applicable solution that will work, or are they just randomly patenting ideas that would hinder their profit?
Actually, your question pertains to patent quality, because the requirement for patents is industrial application. But there are certain solutions when you simply ask yourself how it's possible that there are patents granted, but the patents are. And it's about all patent prosecution, examination processes. I haven't mentioned it here because it's pretty complicated, and I would like to work in my further research on this issue, because I think it must be reformed.
Okay, thank you.
You're welcome.
Okay, for fairness, we go around the microphones. So next, microphone 3.
Hi, if I invent something really awesome, posters on my blog, and if then a company tries to patent afterwards, is that not possible anymore due to prior art then? And if they try to patent it, if I'm safe then because to prior use?
If you post it, then of course, this is prior art. The question is whether patent examiners will find this prior art, because there are cases where patents are granted. After a couple of years, there is found prior art, for instance, in Norway at the university. But of course, then you have also prior use right.
Okay, microphone 4, please now.
Okay, I have 2 questions. One question is, if I invent something, or if I make something that the product of which would infringe on a patent, and I post this on a site like, say, Thingiverse, could I be sued because I don't actually sell the product?
Yes, it could be, because it's public use.
Okay.
Yeah, even if you... Well, as I said that as long as you're low profile, you don't earn money, you're safe. But patent holders can enforce their rights simply to show that we are patent holders. And if you public some certain improvement of patented solution in the internet, you have to consider this option.
So I don't need to make the product.
You don't need to make.
So just publishing the plan is enough to get me sued.
Yeah, if you base on patented solution.
Okay.
Yes.
And the other question is, how likely is it to get sued? Did you look, for example, at software, open source software?
No, I cannot answer. No, I didn't look at the probability. There are certain studies concerning patent trolls and their activities, how many lawsuits, but these studies are questionable, and I don't rely on them, because they measure normally how many lawsuits are in courts by patent trolls. You can, well, I read the press, and there are articles on startups being sued by patent trolls, but I cannot estimate the probability.
No, I think it would be interesting to look at the number of open source projects that got sued.
Yeah, I understand, but I cannot. I don't have the data. But I know that there are a defensive organization, even Linux has some, that they collect patents in case of patent suit simply to defend themselves against patent attacks.
Okay, thank you. Now the Signal Angel has a question. One, please, and then I make the next round.
Okay, hi. Thank you very much for the talk. There was quite an attention also in the IRC. Everybody listened quietly, but they have a lot of questions too, and also similar to the ones already posed. But one is, and maybe we also didn't understand it correctly, but you mentioned that one can only claim experimental use if you have a business interest. Is that right?
No.
No, okay, then maybe somebody understood it falsely.
Yeah, maybe.
Okay, because then it all wouldn't make sense anymore.
Yeah, well, you, of course, you might have some certain commercial intention involved in experimental use, but always in case of troubles in this, with that regard, you have to prove, you have to stress the experimental character of your undertakings, that you wanted to expand, to add new knowledge, find new applications, etc.
So as a private person, like a maker, I don't need business objectives to have a legitimate interest in experimental use.
No,
right?
no.
Great.
It referred only to the doctrine in the United States, because they introduced this legitimate interest to narrow down even the scope of experimental use. But as long as it's for strict philosophical inquiry, then it's fine.
Okay, thanks.
Okay, we got 8 minutes left of Q&A, so please keep it terse now, as I see that there are already 4 plus 3 questions.
Okay, I have a question regarding European patent and the quality of translations. So I had a look at some of the translations into my language, and the quality was horrible. I think that it was very difficult to understand what was that patent about.
Yeah.
And do you think that the bad quality might be a way of defending yourself against patent claims?
What do you mean that?
I mean that European Patent Office publishes European patents in, I think, 4 languages, which are translated by person.
Machines. Also machines.
Yes, into other languages, it's a machine translation, and the quality of it is very bad.
Yeah.
So if I'm a private person and I don't have to know, for example, English, German, French, and I don't know Spanish, I think. So I might misunderstood the claims of the patent, and I might not find the patent, and so I might infringe it.
Yeah.
So do you think that it would be possible to fight against the patent with the quality of the translation argument?
Yeah, I think it's. I have never thought about this, but I think it would be a good option to say simply that it was not possible to understand the technical teaching due to poor quality. Yeah, absolutely, certainly.
Okay, thank you.
Thank you. Thank you very much.
Okay, microphone 1, please.
Could you elaborate a bit more on the distinction between prior use and prior art? The same example as the first question. If I build something, document it publicly, put it on GitHub, whatever has a timestamp on it, and it will not be found while some company applies for a patent. But it's still there, it's in existence, it's documented publicly.
Yes.
What happens at that point if the company has the patent granted in the first place? What happens afterwards with it?
With the prior use, you mean, or
Yeah,
because the prior art is everything that was published before the patent application, just to make clear for everyone. So everything published, patents, articles, leaflets, posts, etc. And the legal doctrine says that the prior use does not equal the prior art. So you cannot invalidate a patent based on the prior use, saying that I did it, I invented, because the idea is that prior use protects trade secrecy. That's a different thing. So I said before that if it's posted, then you have the prior use because you invented first. And if you post it, of course, this creates already prior art. But when you keep your business model secret, and there is patent application later, then the secrecy does not work against the novelty of the later patent.
So the best way to defend our freedom to make things is to make them and document them publicly?
Yes, I think creating prior art.
Okay,
yes.
Thank you.
Okay, microphone 3, please. Then.
I think you've almost just answered my question, but I wanted to make a parallel between the issue of biopiracy and the maker scene, because I feel it's very close in terms of how it functions. That once a company has patented a traditional use of the knowledge of plants, it becomes very difficult, even with the proof of prior use, to invalidate the patent. And a lot of people recommend that to disclose the information as much as possible, so that the patenting office employee could find that content.
Yes.
Is that so?
Yes,
I feel like it's the same thing that should happen with the maker scene. And then I would like to also ask, maybe in complement, how much do you feel the Creative Commons license can help in that process?
I've been asked about Creative Commons license, open source license many times. I don't think it works for patents because of the mechanism behind patents. I would like to elaborate it also in my further research. Well, in my research, I proposed a solution that would work for makers. It's not a statutory limitation because I would fail the first step of Article 30 of the TRIPS agreement, but it's a different solution. There are certain open patent licenses, but what I've seen and analyzed, after all, these open licenses are created around patent pools. So you enter a patent pool with your patent, and you give, you agree to others to use your patents. That's the idea, and that's why I don't think that Creative Commons can be applied in patent law 100% simply by copy paste.
All right. I was just wondering also, because obviously the maker scene is very proactive in inventing things, and so they are actually creating a lot of prior art, which is then just being looked at by big companies that actually have the money to invest in a patent. And well, the person who was here before me was mentioning publishing on a weblog, which I don't think it's necessarily works because it's extremely easy to predate a post on a blog.
Okay.
I was always taught that the best way to date something is basically to just like put a description of the project in an envelope and to post it to oneself and not open the envelope. Do you feel this is a good option?
Well, I haven't thought about it. Actually, when you were asking a question, I thought about applying for patents simply to create prior art and to stop, the patent prosecution after a certain time. It's also a common strategy. Yeah, but of course you need money to do so, yeah? Yeah, that's the point.
Yeah, whereas for this solution, which I was always incentivized to do, you only need to pay for a stamp, basically. And the stamp of the post shows when this thing was made. If you haven't, as long as you haven't opened the envelope, it is a proof of date.
Yes. Yeah, I think it should work.
Yeah. Thank you.
Thank you.
Okay. Sorry, at 4, the Signal Angel is next, and please keep it short.
Sure. So also going to this, do you have other recommendations how to best publish something besides publishing a patent?
Well, as here said, blogs or scientific article. There are also websites not blogs when you publish articles on certain technical solution. I think this should be really good option. Okay, patent applications are said too expensive. Of course, if you can invest, you can do it. But I think creating prior art by publishing information in the internet, that should work. And articles, I think scientific articles should be really fine.
Okay.
Yeah. Concerning the patent documents themselves, as far as I know, they are public domain basically, so I can copy them and I can process them in some ways. So I could, for example, do text recognition on them and vectorize the images, but then it gets very blurry what is usage of the patent in the sense of using it and what is simply transforming the document and building upon the document without using the patent in the way of an invention or something. Could you elaborate on that?
You mean like understanding technical teaching based on the patent? That's your question. I'm sorry.
Just using it for example, to make it easier to make new prior art or something just out of the patents. What can I do with the patent document without getting problems for patent infringement?
What you can do, well, but you are a patent holder, or you read. Well, I said you can try. You can work at home. You can try to work the patented solution.
Oh, I mean in the public. I mean
in public.
When I scan, I could republish a copy of the patent document,
there's right? It's not a patent infringement if you simply republish public document.
But how far can I go when I for example, character recognition should work, that I put this into text, or when I scan it and I vectorize it, but then when I make a 3D model, it's probably not that easy anymore, for example.
Based on the patent?
Yeah.
Yeah, well, I think with 3D models, if you rebuild patented solution, then you might have troubles. But simply posting, the patent, you don't infringe. I'm sorry, but I don't think I understand. I don't understand.
It's just a bit of a blurry line where the implementation of the patent starts and when just processing on the patent document.
Well, I think then you have to get to understand the scope of protection, because I think that's the question. You want to know how much you can work around the patent. Yes, this is your question. If you want to, we can talk about. I'm sorry.
Okay.
Sorry, can you continue that conversation afterwards? We're already over time. I allow for 2 more minutes. That would mean, sorry, microphone 2 won't be getting any speech time. Microphone 1 was waiting too long. I can't kick him. And 1 question afterward from the signal angel. You all both got 1 minute. Go.
Okay, hello. Here there is a very common question. These days, is there any real positive value from the overall patent system to individuals and, let's say, small companies, besides the huge corporations?
For small companies, I would say that if you have a patent, you can attract the investment. If you have a startup and you have some patented solutions, you may simply get new investments into it. That's how.
Individuals. What about individuals?
With individuals, but like with no commercial. Well, you can read, you can understand what's going on, what's protected. You can see the borders, what is actually still free, not patented. I'm very critical currently to the patent system, and I don't see so much positives from this system.
Thank you.
Thank you.
Thank you so much. What's the difference between non-commercial use from experimental use?
Well, non-commercial use means that you don't gain any profits from the activities. And well, the experimental use, if you have private and non-commercial use, the experimental use goes a step further because it allows you public use. You can post information, and as presented on one slide, there are jurisdictions where you can have commercial implications from the experimental use. Well, commercial implications in the United States are completely out of question. Yeah, but well, there's no. I wouldn't differentiate it. Non-commercial use and experimental use. This is different scope. I would say that, as said, private use and experimental use gets public. Mm-hmm.
Okay, thank you. I have to conclude this Q&A session right now. If anybody's got any questions, we have a pause after that talk, so meet our speaker down there.